know we still have people signing on, but why don't we go ahead and get started? Welcome, everyone, to the second part of our webinar series, Managing Your Workforce and Complying with Colorado Law. We're very happy to continue with this series. My name is Mark Waletsky. I'm a labor and employment partner with Holland & Hart. And joining me on today's panel are Deborah Hake, my colleague in our Denver office, Greg Klauser, who's director on ACC's board and senior employment attorney with Empower Retirement, and Karen Dean, also with Holland & Hart, a tax attorney and specialist, and we're very happy to have all of them with us and all of you with us today as we talk about some new laws that are impacting probably all of you and just some changes that we think may be impacting you and your workforce. Let me see if I can get this to advance. That's not working. Bear with me a second. Gonna skip that. There we go. So just a couple of basic announcements before we get started. One is after the presentation, you'll all get an email with the recording of the presentation, a copy of the slide deck that we're going over, an affidavit for CLE credit, and links to other parts in this series. And we absolutely welcome you to, if you haven't already, sign up for the remaining parts in this series. I also want to note you're all muted, but that doesn't mean we don't want this to be interactive. We really do. So to the extent you have questions, please don't feel like you need to hold them to the end. We may not get to every single question that's asked, and there is a question or a chat function that you can use. Hopefully you all see that on your screen. But we'll definitely do our best to answer them in real time as they come up. And so really feel free to jump in with a question. Let us know if you have one, and we'll do our best to answer it. It may not be immediately when you ask, but we'll do our best to stay on top of it. So today we're going to be talking about promotions with respect to really the new requirements under Colorado's pay equity law, the Equal Pay for Equal Work Act. There are significant new requirements that, if to the extent you haven't seen them, they're new, they're unique, really, to Colorado, and we want to run through some scenarios to ensure that everyone's aware of how the law and really how the world in Colorado has changed. And then we'll be talking about sick leave policies under the Healthy Families and Workplaces Act, and really kind of getting into some of the more subtle issues that we've seen clients facing as they are working to implement these new rules. We're also going to talk briefly about vacation policies, and Karen is going to cover the issue of working from home and payroll implications, because as many of you and many of our clients are seeing, we have a number of employees who are not and have not been in the office, and they may not be even in a location where the company has an office. So she'll be pointing out some things to keep in mind with those types of issues. So without further ado, I'm going to turn this over to Deborah to talk about promotions and pay equity. And Luke, if you could switch the controls to her, that would be great.
All right. Thanks, Mark. So as Mark said, the Equal Pay for Equal Work Act went into effect January 1, and it does a bunch of things, but key to this presentation are the new job posting requirements for promotional opportunities. In short, you've got to post promotional opportunities and give notice to any Colorado employee to whom that job would be a promotion. And you have to communicate the notice in a reasonable manner. It could be via email or the regular method of communication. Could even be on an internal job board, as long as the employees know that the postings are going to be made on that site. So let's start with when you have to provide that notice. Here's the first scenario. You're hiring for a VP position in New York or another country. Do you have to post? Well, the job is not in Colorado, so you might think no, but the Colorado Department of Labor and Employment has said that you have to post the position so that Colorado employees can see it. Now, usually when you post under this new act, you have to include the position's compensation and benefits in the posting. You don't have to do that with jobs that are performed entirely outside of Colorado or with postings entirely outside of Colorado. Now, what if you don't have executive positions in Colorado? Well, you still have to post because it could be a promotional opportunity for those Colorado employees. But if you're concerned you're going to get a lot of applications, you can say that you're going to have the position be subject to certain qualifications that would end up excluding most of those Colorado employees. I will say this answer and a bunch of other answers are potentially subject to change. There's currently a challenge pending in district court in Colorado regarding the act's legality, especially about its far-reaching impact on businesses that conduct activities in other states. So we'll keep you updated with how that lawsuit's progressing. But in the meantime, all of the act and its regulations are in effect. So if we turn to the second bullet, what if you want to move Tim from customer service rep 1 to 2 because he's been in the position for a little over a year and he's demonstrated basic proficiency? This touches on the area where I'm getting the most questions. What are the requirements for inline promotions like this? Or maybe there isn't somebody leaving that CSR 2 position, you're just trying to bump Tim into the new one. According to the Colorado Department of Labor and Employment, you have to post an inline position like this. Even though it's not a vacancy in an existing position, it's considered a vacancy in a new position. If that inline promotion gives existing employees a new position, including by changing their title and or materially changing their authorities, duties, or opportunities, then you have to post. Now, if all you're doing to Tim is you're changing his pay or adding to the title that he achieved a degree, like a CPA, you won't have to post. So, Greg, I'm curious about your perspective from the in-house angle. How is this interpretation of posting for inline promotions going to affect you? I know that some employers are talking about removing all inline promotional opportunities altogether so they don't have to post. Are you considering going that route? Oh, I think you're muted, Greg.
Sorry. Can you hear me now? Hopefully so. We are not thinking about taking that measure. You asked how it's affecting us, and this is a French legal term, but it's a shit show. This is really disrupting how we've done business, how our HR teams have done business, right? And suffice to say, there's a lot of resistance internally on my HR teams on how and whether we should do this. Do we really have to do this? Do we have to do it for every single thing? And so one of the things that, maybe people can chime in on the chat on this, and maybe both of you have opinions, but at the end of the day, I think I'm trying to take a more optimistic approach and just say, what's the harm in posting or even over posting internally for a period of time for these positions? I think it does create extra work for sure, but in doing so, we can stop negotiating internally and fretting internally about whether we should or shouldn't post. maybe we just say, let's just post everything and be done with it. And that's something that we're thinking about, right, that we're trying to move toward. But it's not without resistance, of course.
Yeah, absolutely. I'm hearing that similar perspectives from a bunch of other clients as they're trying to wrestle with how this could fundamentally change their recruiting and hiring practices. I see in the chat there's a question, how long do postings need to be up and how far in advance of a promotion? So the Act doesn't give any hard or fast rules on this. It doesn't say has to be posted for 10 days or else. But I think this question really gets to the issue of good faith. And the Act does say you need to make your postings in good faith. So if you already have a candidate in mind, you post the position, and then you fill the position later that day with your candidate in mind, you may not have satisfied the spirit of the law, at least according to the Colorado Department of Labor and Employment. But I think we'll see the bounds of this as time goes on. We're still in the very early stages of interpreting the law. So we'll know more soon, hopefully. Or maybe we'll get another guidance. Who knows?
Can I ask I just wanted to ask a quick question, and it's something that I'm sorry to surprise you with this question, but how does this law and the promotional opportunity rule play in the realm of restructuring or RIFs, right? If we're reorganizing a department and people are going to be moved around, some positions will be eliminated, some people will be moved around within a department or across departments, does that mean we have to post those positions as well as part of the RIF?
I think I can't speak for the department, but I think they might say yes. If you're materially changing the job duties or the opportunities for those employees, changing their titles, not changing their titles, all of those are going to be a factor in whether you've essentially created a vacancy in a new position. So at this point, since we're in the early stages, we're telling all of our clients to err on the side of posting and to not try to be the test case for some of these questions if you can avoid it.
Yeah, and I think the tricky part is that in a RIF situation, you're doing a lot of that reorganization work behind the scenes confidentially, working with some key leaders and key HR people to decide how the impacts are going to be felt across the organization. As you're making those decisions, you sort of come to a point where you think you've settled on what the new organization will look like, and that seems like an awkward time to then start posting because there's no context for it necessarily. You may not even have announced the RIF formally and let people know. So maybe there's a nexus with the confidentiality exception that is in the rules. I don't know. But it seems like that's not always going to apply because sometimes it's just moving people around. I don't know. This seems problematic to me in how you actually would effectuate this.
Absolutely. Like you said, there's that confidentiality or that incumbent exception where you're trying to replace somebody who doesn't yet know that they're going to be fired. And so there are interests in making sure everything stays confidential in that case. So you're right, that could definitely play in. But whether that exception will broadly cover an entire restructuring, it's hard to say. All right, so let's go to this last bullet here. What if you want to change Sharon's title from marketing manager to marketing supervisor? Well, if she's getting a supervisory role for the first time, even if her pay doesn't change, the higher title and authority that she gets is going to create a new position that will be considered a promotional opportunity that you have to post for. Now, if she's already supervising people and this change doesn't materially change her job duties or what she's doing on a day-to-day basis, it's a closer call. But like I just said, when in doubt, we're recommending post. And the last thing on this...
there's a question. How does this affect reassigning duties to fill vacancies? I think the question is similar to what Greg was asking, but slightly different. So if you're moving duties around because there's a vacancy, does that mean you've got to post it and allow others to apply?
If we interpret the department at its word, where the department says if there are material job duty changes, you have to post, then I would say yes. But as a lot of these questions bring up, there's so many complexities that the department has not yet issued guidance on. So I think that answer could change in the coming days, but for now, we're erring on the side of posting. All right.
I think I would definitely agree. The only other thing I would add to that discussion, I think Deborah hit the nail on the head with this, is, this is a brand new law, and so taking a more conservative approach is often the best one from a risk management standpoint. On the other hand, this is running smack dab into just general business needs and operations, as Greg mentioned. And so the clients that I'm talking to are really struggling to find that balance of how much risk can we tolerate versus how much are we going to turn upside down our process, for example, for a national or global company to meet the needs of one state where we might have only a small slice of our employees. And that's a real tough balance to make, but it's clearly not just a legal question in these situations.
Absolutely.
Yeah, I could just expand on that, Mark. I mean, hypothetically, discussions in some companies might go so far as to say, who cares? We're willing to take the risk because we think the risk of enforcement or the risk of getting caught is relatively low. What's the cost internally from the business and the disruption versus the likelihood of getting caught and getting slapped with something? And I know we don't know how to answer that question of really what's the risk, how likely is it, and what's that going to look like necessarily. But I have to say I find myself having a hard time arguing that we should fundamentally transform our entire processes when I'm unsure if the risk is really that high.
Absolutely. I see another question. Is there a small employer exception? There is not. And I see another question. So to confirm, if we're a Colorado-based company and we have an opportunity in our Houston office, which would be considered promotional, do we still have to post the opportunity internally but without the compensation information? Yes, to your Colorado-based employees, yes. Will a copy of the slide deck be sent following today's webinar? Absolutely, yes. Okay,
and just to confirm that on that last point, as I read the rules on the posting for the promotional opportunity, if you're posting for a promotional opportunity, I think the CDLE is taking the position that the compensation information may be required. So I would be careful that, I mean, the CDLE, and Deborah, please jump in here, but as I read it, the division has said, look, you don't have to post for a job. That's helpful. But the problem is, if you're going to fill a vacancy and you're not posting it, you still have the promotional opportunity postings that are required. And you do have to post that. And at least as I read it, I thought that the CDLE was saying, yeah, if you're posting for a promotional opportunity, then the comp and benefit information has to be required, has to be included.
Yeah, I think on the latest interpretive notice we got, it says the employers don't have to disclose compensation for jobs that are performed entirely outside of Colorado. But yeah, it's limited.
Yeah,
okay.
And that's the hard part is they have that piece in there about jobs completely outside of Colorado, but they don't marry that guidance up with the promotional opportunity piece. And that's why I had the concern, and that's why I'm saying it may be required because, again, a lot of this stuff is we're getting this guidance in real time and, the past few weeks. No courts have weighed in on it. So it's unclear at this time exactly how wide-ranging some of that, some of those rules and some of that guidance will really be applied.
Agreed. So what has to be in the posting? We pretty much covered this already. You have to include the compensation or the range of compensation and a general description of benefits, including health insurance, retirement, PTO, any tax reportable benefits. You don't have to disclose if it's a minor perk, like access to an on-site gym. So at least there's that. Managing expectations with inline promotions. So this is more of a business HR point, which is posting for more positions is going to have an impact on employees. Maybe it empowers them to apply for more in advance quickly, but it could also be potentially demoralizing for an employee who sees a posting for that inline promotion that the candidate thought they were a shoo-in for, that would have been just an automatic promotion beforehand. So what can you tell that candidate? This goes back to the spirit of the law. Probably a bad idea to tell the candidate that they're a shoo-in and you're just posting so that you can comply with the law. I think the department might say that's not quite enough. You need to make that posting in good faith. And if you're concerned about getting too many applicants, you can always post widely, but then limit the qualifications that are needed for that position, so you do still end up with a smaller pool of candidates. You don't have to interview the incumbent. And finally, exemptions to providing notice of each promotional opportunity. Hope is not lost. There are some situations where you don't have to post for. So the first one here is regular hires. So let's say you're continuously accepting applications for, and you hire at least one a month of salespeople. And this could be a promotion for some employees. Rather than continuously putting out postings, what you can do is you're allowed to send a monthly email to employees on the last day of the month with that notice. Inline promotions. Now, we just talked a lot about how you have to post for inline promotions, but there are a few limited exceptions to this, because why make things straightforward? So the first one is you can automatically promote employees after they complete certain requirements. So for example, you promote a junior haberdasher to a senior haberdasher once they complete 500 hats. If you put a notice of this promotional opportunity in the handbook, you notify employees that the opportunity is posted in the handbook, and then you update the handbook if there are any changes to the pay or qualifications. Say now they have to make 600 hats before they're eligible. Then you don't have to post each time. The other inline exception here is if consideration for the promotion automatically follows a trial period of 1 year or less, and the commitment to consider the employee for promotion is in writing. So this could be you hire somebody on a 90-day probationary period, and then based on their employment and your needs, you convert them into a full-time employee. You don't have to separately post for that full-time. Okay, next up here is the incumbent who's not aware of upcoming separation, which we already touched on. And then the last exception, which isn't here but is small, is that you don't have to post for temporary acting or interim positions that last up to only 6 months. And with that, let me turn it back over to Mark.
Great, thanks, Deborah. And on that last point, Greg, I'm curious how what your thoughts are coming from an in-house perspective on these exceptions, because the Colorado division was very limiting in these exceptions. It was nice to have some, but they talked about these every month you do an inline promotion or you're hiring for the same position every month. And the clients I've spoken to said, well, we do inline promotions. We do a bunch in the summer. We do some in the fall, some at other times, but it's not every month. And it's not quite as regular as what's outlined in the exemption. So I'm curious if from an in-house counsel perspective, if you have thoughts on that piece.
Yeah, thanks, CDLE, but no thanks. I mean, these things are helpful, but they don't fix the real problems that we're encountering. So we have classes. There are some positions for which we have essentially an evergreen requisition. They're always posted externally and thus internally. And so for those, I think that might, I would argue, fall into this regular hire line item. The confidentiality or incumbent one is rare. We're rarely going to use that. These things are nice to have, but we're rarely going to be able to rely on them. So they're not that helpful overall, unfortunately.
Yeah, that's been the feedback I've been getting too, is that it's really hard to completely fit in these within these exceptions. So maybe the division will will expand some of them, or maybe the courts will say, look, this is too restrictive. Either with the current challenge or with any upcoming challenges, and I'm sure there will be some.
Yeah, I think as employers, we should not be afraid to press the levers of our democratic process and working with trade organizations or the chambers of commerce or whatever it is we do in the legislative sphere to try to influence these things, to shape them maybe. After a period of time, maybe they'll be more receptive if they get a lot of noise from employers that these are not workable solutions. I know, the intern or the temporary 6 months or less, that's something we will use, and we'll also use the bit where you put the notice automatic promotion within 1 year. We'll use those things, but those things are just really working on the edges. And so, as I said before, this is helpful, but this does not really concerns most employers have.
Yeah, exactly. Oops. Did I skip one? There we go. That was just the intro slide. So now we'll talk about sick leave policies and particularly requirements under the Healthy Families and Workplaces Act. And what I really wanted to talk about and frame this discussion around was current policies versus a new policy, because that's the question that I've been seeing a lot is, can we use and or modify our current policy, or do we have to come up with a whole new one? And Greg, this is another one where I'm interested in your view. Maybe before I jump in, what are your thoughts? Because my hunch is you've probably already dug into this at your company. And so what have been the biggest issues that you've seen in terms of big picture current policy versus coming up with a new policy to comply with the requirements of the HFWA?
You overestimate me, Mark, because I'm woefully behind. Here yet, so don't expect me to be fully compliant, even though it went into effect 3 weeks ago. I think when we looked at this, we decided that we would use our existing PTO policy in place of because we are way more generous at our company at all levels, even for new hires, than the minimum required by the law. And we are in all 50 states plus 4 territories. And so we're trying to come up with one solution that governs all, instead of trying to come up with state-by-state policies. And so while with the trick, though, of course, is that there are some nuances in the Colorado rules that we may not be compliant with yet because, again, we're trying to size it for 50 states plus. That's hard to do when you've got sizable populations in other states as well. How do you manage the Colorado rules for the 2,000 employees we have here versus the 2,000 we have in Massachusetts versus the 2,000 we have in Wisconsin versus et cetera, et cetera. And so turning that boat, turning the big ocean liner is difficult to get some of these smaller pieces incorporated into the policies. Yeah,
fair point, and that's exactly the type of thing that we've been hearing too. And frankly, from a legal perspective, sometimes clients will ask, well, can we just do a separate appendix for a different state? And the answer is, of course, you can absolutely do that, but someone's going to have to manage it. and someone's going to have to administer all the different rules. And so what I have heard, and I'm guessing Deborah has heard this too, is exactly what Greg has said, which is clients really want to use their own policies, their existing policies, rather than coming up with a whole new one, in part because it's a big ship to turn, as Greg mentioned, but also in part because if you end up creating a whole new policy, then you've got to juggle, okay, are we going to give a whole new bucket of leave without taking away any leave? And if we take away any leave, how is that going to go over? So that's why I really wanted to talk about this in the context of current policy versus coming up with an entirely new one. We'll address all the same requirements, but let's just jump in. Just as a reminder, the Healthy Families and Workplaces Act sets up a couple different categories of leave. One is really for sick and safety purposes. Employees must be able to accrue 1 hour for every 30 hours worked, up to a maximum of 48. That's the baseline that the HFWA sets up. And this year it applies to employers with 16 or more employees, and then next year it applies to all employers in Colorado. But the law also contains a requirement for public health emergency leave, or PHE leave, which is really COVID-related leave in the current circumstance. And so that's the first place where I've seen a potential issue with the existing leave policies, is that there is literally no mention of this supplemental public health emergency leave of up to 80 hours, which the Colorado Division of Labor and Employment clarified on December 23rd, I believe, that yes, PHE leave does kick in as of January 1, 2021. No, you can't count the leave that you gave in 2020 toward that 80 hours. This is a new period. This applies for the rest of this particular pandemic. But as of January 1, if someone had only 10, 20, 30, 40 hours, whatever it is, of available leave, whether it was sick leave, PTO, whatever it is, and they needed leave for COVID-related reasons or reasons related to the current pandemic, then you need to supplement their leave to ensure that for a full-time employee, they can take up to 80 hours for those reasons, and for part-time employees, it's proportionately less. The rules also clarify that if someone needs public health emergency leave, and that same leave would count towards sick leave purposes, you're supposed to use the supplement before you dip into their accrued balance. So again, if someone has 40 hours of accrued leave on January 1 and needs some public health emergency leave, the first 40 hours of that would be provided via the supplement before you dip into the accrued hours. And that, frankly, leads into another issue that we've seen. A lot of our clients and a lot of companies out there have waiting periods where they need to wait 30 days or 60 or sometimes 90 days before they can use the available leave that has been accruing. And even if your policy, as Greg mentioned, is much more generous than what is required under the law, if you have a waiting period, you've got a problem, because that conflicts with the requirements under the Healthy Families and Workplaces Act. The accrual minimums, most of the companies that I've worked with not only meet, but they exceed. Again, as Greg mentioned, they're much more generous than what we've seen. But again, make sure that applies to all employees. We've reviewed a number of policies where everyone was thinking they were fine, super generous leave as compared to the HFWA, but there were certain categories of employees that were exempted out. Maybe they're part-time employees, or maybe they're, temporary workers employed directly by the company. There really is no carve-out. If they're working, and even if it's part-time limited hours, whatever it is, they need to start accruing 1 hour of leave for every 30 hours worked, or you can give them the amount in advance. But again, even if you do the advance, make sure that you're advancing enough so that it would meet the minimum required under the Act. The other issue that we see is carryover. For folks who use a California-esque policy, or they, have a policy that is designed to ensure that there's no loss of accrued time off, you're likely not going to have an issue. But for those folks who say, hey, you've got to use everything before the end of the calendar year or the benefit year, you potentially, again, have a problem with your policy, even if your policy is much more generous on the accrual of leave. The Healthy Families and Workplaces Act makes clear that you have to allow people to carry over at least the 48 hours that they could earn in the year. So be careful about that. I also see there's a question to clarify, do they have to use a supplemental leave before using the accrued leave? Yes, according to the rules, if the rules state that if the public health emergency supplemental leave would also count towards, for example, sick leave under the Act, and in most cases it's going to, then you have to use the supplement before using the accrued leave. Now, again, the way I interpret this, without the benefit of having any court guidance on this, is that if someone has accrued 40 hours and they need this COVID-related leave, then the first 40 hours of that COVID-related leave would not be charged against their accrued balance. But after that, if they still have 40 hours available and they need another 40 hours, then you could use their accrued balance, because the law states you have to supplement what's accrued to get them up to the 80 hours for full-time employees. Now, again, there's not any court guidance on how this is supposed to work yet, but that's my best read on that. And another question: what about interns that don't have any benefits, vacation or sick? Do they qualify to accrue hours under this Act? If the intern is an employee, then yes, they would. It doesn't matter what their title is. So if you call someone an intern but you pay them as an employee, then they would be entitled to accrue hours under this Act. If they are really considered just an intern, they're not receiving any pay, and they wouldn't qualify as an employee under the law, then I think you have a good position to say, no, interns aren't going to be eligible because they're not actually an employee. They're not receiving any pay. They're doing this for credit. But again, keep in mind, there have been and there continue to be challenges out there to intern status as a non-employee. So just be aware that is a possibility. Okay. The other issue or issues, I should say, that we see with respect to existing policies is that the rules on use are not always consistent with the requirements of the HFWA. And what I mean by that is we've seen some policies where they say you can use your time off for these 3 or 4 reasons, and it wasn't meant to be so constricting, but in hindsight, it is. It doesn't mirror all of the reasons for which someone could take the leave. And what we've done is with those is a couple things. One, you just remove the restriction and you let people know that they can take the time off for whatever health, safety, or public health emergency leave is required under the law. And you can even link them to the poster that the Colorado Division of Labor and Employment has put out that, hopefully is being distributed to your employees. Or you can literally just list the different reasons that are set forth in the Healthy Families and Workplaces Act to ensure that you're covered. Another issue is documentation requirements. I've seen some policies that require documentation for any type of sick leave, whether it's an hour, a day, 2 days. And again, under the HFWA, that's not allowed for sick leave unless they miss 4 or more work days. So be careful if you have those kinds of requirements. Similarly, the increments of leave. I haven't seen this as much, but the Colorado Division of Labor and Employment has said, look, you can have increments of leave in hourly or less, which means you can't require someone to use a block of 8 hours at a time, for example, of accrued leave. That would be inconsistent with the purposes of the Act. And lastly, and this is a piece that I think all existing policies probably need to be amended to address, is if you have an existing PTO policy that can be used for vacation, personal day, or sick days, or any of the reasons mentioned in the new Healthy Families and Workplaces Act, that's fine, as long as you tell people that if they exhaust their leave for non-HFWA reasons, then they are not going to get more if they have an HFWA qualifying leave. And what I mean by that is, let's say you allow employees to accrue up to 80 hours. You're way more generous than what the HFWA requires, because it only requires 48 for non-pandemic related leave. And let's say an employee takes 80 hours worth of vacation time. And they do this, and then let's say that happens by July. So they've got no leave left. And then in August, they have an HFWA qualifying leave. Maybe they're sick. Maybe there's been a domestic violence issue that would qualify under the Act. There's something. And they say, hey, I need some additional time off, and I'd like it to be paid because this is protected under the Healthy Families and Workplaces Act. If you've told people in advance that they do not get additional time if they exhaust their existing leave, then you don't have to provide them with additional paid leave. If you do not have that in there, then your policy under the rules is not compliant, and arguably the division or the employee might say, I was never warned about this, and so I believe that I should be entitled to more leave. Again, courts haven't weighed in on that rule yet. We'll have to see what the courts say about it, but that's the division's interpretation of the statute. And of course, the division also wants you to let employees know that this policy complies with the basic requirements of the HFWA. There won't be any retaliation for use of leave, and basic reminders like that. Otherwise, the division may say, yeah, you've got a nice policy, it's more generous, but you didn't comply with our requirements and our interpretation of this statute. Greg, anything else from an in-house perspective that you're seeing or that you want to add with respect to these new issues? I know like the promotion decision, is definitely a challenge.
Can you just make it all go away, please? That's what I want.
I wish.
Yeah. Hearing you go over these points, I think I have an opportunity, shall we say, to go back and review the guidance and line it up with our leave policies to make sure we have all these nuances in place, because I'm not confident we do.
Yeah, and I would definitely recommend, for those of you who haven't reviewed the guidance that's been put out by the Colorado Division of Labor and Employment, it's not the be-all, end-all. There are definitely some ambiguities, but they are worth a read. Those the guidance gets updated from time to time. The latest one, I believe, on the pandemic-related leave is Interpretive Bulletin and Guidance number 6C. And so those are definitely worth the read. And frankly, it's worth going back to the website every so often. And if you don't know where it is, let us know. We're happy to point you to it. But that is something worth going back to from time to time, because they are updating that regularly. So with that, I'm going to turn this over. Whoop, one last thing. I'll do this very quickly. If you have a benefit year that's different than the calendar year, just make sure that's clearly defined, and make sure you're tracking the leave if it's for HFWA purposes, so that you know when people have used what's available to them. So with that, let me transition it. I meant to transition it to Deborah for one quick slide on the vacation, and then we'll turn it over to Karen.
Perfect, thanks. I just want to take a minute to go through this because I'm really interested in what Karen's going to talk about. So the CDLE has issued a regulation stating that use it or lose it policies on vacation are prohibited, and that accrued vacation has to be paid out at termination regardless of whether you've got a policy to the contrary. There have been a couple of challenges to these regulations, and 2 courts have concluded that an employer can refuse to pay a former employee the accrued vacation once they leave based on the policy. For example, the policy says if you don't give 2 weeks of notice, you forfeit your accrued vacation. The Supreme Court of Colorado heard oral arguments in early November on this issue and is expected to decide the question once and for all later this year. So the takeaway is, unfortunately, that it's still a bit up in the air on whether you can have a use it or lose it policy or say that employees forfeit vacation at termination. But hopefully we'll know in the next few months. And with that, off to Karen to take us home.
Okay, let's make sure I can move the slides. Okay. So what I'm going to talk about is something that I think we are all experiencing, as y'all are peering into my living room, is working from home. And, you know, with the pandemic, you know, I think most everybody is in that situation who is able to work from home. You know, I think there's going to continue to be a long-term impact, because you've already seen companies like Google and other folks saying, y'all don't need to come back to the office ever. You know, I'm hearing from clients that, well, even if we do come back, it may be part-time, you know, 2 days in, 3 days in, things like that. So what does this mean from, you know, a tax perspective? And I know that there's a lot of other issues that I won't talk about, but that are implicated by having your employees working remotely. But at least from a tax perspective, there's a whole bunch of different possibilities. I've highlighted in yellow the payroll and employment tax issues, mainly for the payroll withholding. But just to be aware, when you have an employee, if you're a Colorado-based company and you have employees working remotely in different states, but that's not typically their home, you could have a whole bunch of other different requirements that you get subjected to. And so this is just giving you a list of those things that could be implicated. And, this isn't just a United States issue. It definitely is also something that, and it's beyond kind of what I'm going to talk about, but it also applies if you're a global company and you have employees who want to be working in different countries. In fact, this has come up, at least a couple of different clients have said, y'all may have seen, like Barbados said, hey, come live here, work here during the pandemic. That people have asked that, and it creates some issues and concerns from an income tax perspective, in addition to some other issues. But with respect to the wage, the payroll tax withholding, typically, it's not an issue if we're all sitting in Colorado and working for a Colorado company. I'm getting Colorado withholding, right? But where it does become an issue is, where I'm sitting in Nebraska. I decided to go hang out there for the pandemic, but I'm still working for a Colorado company. There's a couple of different rules that apply. Generally, employers withhold based on where you're performing your services, so your resident state. There's some exceptions. I've listed just one example of reciprocity. If you're working in D.C. but you live in Maryland and Virginia, they're not going to withhold. They'll withhold your tax of where you're living, not D.C. tax. Interestingly, I'm not aware of Colorado having reciprocity with any other states, but you can find lists of different states that have different, like New Jersey, PA, things like that. One of the other exceptions is something called the convenience of the employer test. And this has been litigated pretty heavily in New York, especially for when you have employees living in, for example, Tennessee because they want to. This was a case called Huckabee that ended up going up to the Supreme Court, but they didn't hear it, where Tennessee doesn't have an income tax, but this individual was having New York tax withheld even though he was not working in the state. A whole bunch of other states have similar rules. Massachusetts has implemented a new rule as a result of the pandemic that mimics this. And I'll talk about that in a little bit because that's created some consternation with some of its bordering states. One of the things I think that is a little bit surprising, even taking aside working from remotely in general, is when you have employees traveling for work, states, some like Colorado, for example, has a day one rule that says if you are coming into the state to work here, you need to be paying tax. And I see that there is a question: is there a minimum time frame working in the other state for this to apply? That is an excellent question. That is the safe harbors question mark that I have there. And some jurisdictions do have one, others do not. It's a day one rule. There has been federal legislation introduced for the past 5 or so Congresses, and I expect it'll be introduced again, that's trying to implement a 30-day safe harbor nationally. That doesn't ever really seem to go anywhere, but who knows with this new Congress if it will. And I did make the point that, even not necessarily employees, but you might want to check if you have board of director meetings here and you have people coming in state. I know Colorado has been active in that area. So just something to keep in mind. So with the pandemic, I think when you take a step back, looking at, especially if you're, a national company and you have employees everywhere, some states have taken the position that, we're just not going to worry about it. If you have employees who've decided to, leave their resident state and work in a different state, I think we've all seen people moving to Colorado and mountain towns and things like that from other states. They're going to kind of ignore that. So that's one thing that is interesting. It's all across the board. It runs the gamut how the states are dealing with this. Most of the states have not issued guidance, and it's unclear how they're going to enforce it. And I don't know that everybody really thought that we'd still be sitting here almost a year later, not going into the office. So it's it's going to be very interesting to see what the states are going to do, especially as they start looking at budget shortfalls. So
Karen,
going back,
if I could just ask you a question. I want to go back on the question that was posed to you, because as in-house counsel, we're sitting here and we're grappling with the reality that we're all working remotely, and some employees, lots of employees, want to work from different places than their normal home state residents. And we as a company are challenged with trying not to say no, and trying to find some way to accommodate that. And this goes to the heart of the question, right? And I know there's no right answer. It depends, because every state has different rules. But if you're an employer trying to come up with a policy for your multi-state employee population, how do you just stick your thumb up in the air and come up with a 2 weeks rule, a 3 weeks rule, a 30-day rule, and knowing that you're going to be out of compliance in some states, but the risk of prosecution, the risk of getting caught is relatively low, and so you do it because it's easier to administer? Like, how are we as employers supposed to navigate that, knowing that we may have risk, but we're still trying to come up with something that is workable for our population that doesn't just piss them off because we say no to everything?
And that's an excellent question, and a lot of companies are grappling with that. I mean, these issues existed pre-COVID, right? It's just they've been exacerbated by this newfound mobility. It's like, well, if I can work at home, I can work from the beach, I think that companies take a different approach. Some have said, well, this is just temporary. We're just going to, withhold where they're resident the way we used to, continue same as usual, right? Others have looked at their highly compensated employees because those are the ones that are going to get the most scrutiny. And, there is different companies who offer programs that, they can put little trackers on people's computers, and that raises a whole lot of heartburn for other reasons, but, just find out where their employees are. So there's not really a good clear-cut answer, because this is a very difficult compliance matter, but there are companies that have software that do try to replicate this, but, it's like, how much do you push back? You can implement, your own sort of safe harbor, which may satisfy most jurisdictions. A lot of it is sort of asking your employees to sort of self-report, right? Like, hey, have you guys, especially your highly compensated ones. So, there really isn't a great answer. But it's going to be interesting to see, like I said, hopefully there will be some federal legislation. I'm not so confident that the Supreme Court is going to take this new case, this new issue on this slide, this New Hampshire versus Massachusetts. I mentioned earlier that Massachusetts has implemented a new rule that basically said if you were commuting to Massachusetts pre-pandemic and now you're working from a different state, we're still going to tax and require you to withhold on your Massachusetts income. And, New Hampshire doesn't have an income tax, but it has an awful lot of residents who were commuting into Massachusetts. So it filed a suit against Massachusetts in the Supreme Court, arguing that their rule violates the Commerce Clause and the Due Process Clause of the Constitution, because there aren't sufficient ties to the income when someone's working wholly in New Hampshire. I think it got referred to conference for tomorrow, maybe. So we may know next week if they're going to take this case. Right now, they've had a lot of states kind of join in to say it should be heard. There's a lot of support, not surprisingly. New York and other states that have this convenience of employer rule have objected to them taking the case. But it'll be interesting to see that. And I think if they do take it, this will be kind of a step forward in trying to understand, what the landscape might look like. I've talked to some of my colleagues at, different firms and internally, and I think we're out of time. But they think that actually, like, from a compliance perspective, this convenience of the employer test is probably the simplest. Like, we're just going to withhold where we're based or where and that's it. But is that the right answer? Probably not. With that, I know we kind of ran out of time, and I didn't provide you any real answers, Greg, but if you have any questions, feel free to reach out to me.
Well, thank you, Karen.
This is a complicated issue. So, and I've been going around for months on this internally, and I know other companies are as well. So I think the fact that you haven't provided answers isn't a comment on you. It's just that this is a really complicated and unsatisfactory area that needs resolution, right?
Right. That's exactly right. So who knows? I mean, I would like to say that we'd have federal legislation at least providing some relief on this, but it hasn't gone anywhere in the past years, so who knows? But it does have bipartisan support, so we'll see.
Great. Well, thanks, Karen. That is a really important topic. Really appreciate you sharing, and Greg and Deborah, same. Thanks for sharing this information, and to everyone who attended. Really appreciate the opportunity to present this information to you. We will share it all, as I said at the beginning, via email. If you have any comments or feedback or other topics you'd like to see, obviously let us know, let Greg know. Happy to keep that in mind for future presentations. Otherwise, I hope everyone has a great rest of your day.